Alright, so for today's video, we will be talking about state jurisdiction over non-estate residents. And we're going to talk about 4 cases today. I could make 4 separate videos, but these cases are all interrelated enough to a degree that it's kind of important for me to talk about them. Now, the first case we'll be talking about is Penoyer v. Neff. Penoyer v. Neff, as a background, is a pretty old case. It's from the 1860s, which is just the tail end of the era in jurisdictional history where the cases are almost deliberately hard to read. If you've ever read Marbury versus Madison or any of those other cases, they're very difficult sometimes to fully comprehend what is being said in the case. But Penoyer versus Neff is a very foundational case, so it's very important to read, like Marbury versus Madison. Sometimes there's old cases that should not be used anymore, just out of a necessity for comprehensibility. But Penoyer v. Neff is foundational enough that it needs to be read. So, also to be clear, all of these cases we'll be talking about are Supreme Court cases. A lot of the previous cases we've been talking about have been district courts or appeals courts or something. These are all Supreme Court cases, and I just do like to note when it's a Supreme Court case, since it's a lot more iron-bound than anything but a Supreme Court case. Obviously, again, court of last resort, the final court, the court that gets to put down the final opinion. Their opinion is significantly more important than anyone else's on the chain of jurisdictional command. Judicial command, I think, might be a better phrase there. So, Penoyer versus Neff. Actually, real quick, let's discuss some Latin terms, and then I'll explain Penoyer v. Neff. Latin terms, yay, everyone's favorite. So, 3 kinds of jurisdictions that a state might have over someone: in personam, which is power by virtue of presence or domicile within a state. If you're in a state at a certain time, you can be summoned by them. These are all civil cases, by the way. You can be summoned by them or summoned by someone else within the state to answer for a lawsuit. Same is true if you domicile in that state. So if you're not there at the time, but you are a resident / someone who lives in the state, then yes, you would still be, even if you're not in the state at that exact moment, you would still be subject to the state court's power. Then there's in rem. That's power of the court by virtue of someone holding property within a state, and the status of that property may be determined by the court of that state. Now that's a very important power, as say someone flees the state, so you can't bring them to court because they don't live there. Their property within that state can still have issues determined, right? Say there's a boundary issue or there's a possession issue. And then there's a quasi in rem, which is similar, a judgment that's issued against someone as a result of, let's say, them not showing up for case default judgment. A quasi-in rem jurisdictional power would be a ability to have recovery of property within that state. So say somebody blows up your house with a bomb. Now, obviously that's a crime, and there would be other issues, but just for civil issues, and they flee the state, and the state can't get them because they don't live in the state, but they own a house in the state could give you their house to cover the general value of your house, assuming they're of similar value. Or maybe it's not enough value, but it's still as much as can be acquired by that state. So the state can take property as part of a judgment. So here in Penoyer v. Neff, the Supreme Court does make a few different distinctions about these 3 kinds of jurisdiction. It also put some conditions on them. So Neff sued Penoyer through money judgment, gained a tract of land in lieu of that money. Now, the lawsuit is very messy behind this, very messy, and ultimately kind of irrelevant to the actual law of the case, but just for fun, I'll tell you a couple of the interesting facts. I think the most interesting is that he was required to tell Penoyer he was required to send him a actual summons or to summon him through publication. So he found one of the smallest publications that he could in the state that he was in, not the state that Penoyer was in, and had it published there, which under the court of Oregon, that actually counted. Now, the Supreme Court told them in the politest way that was not appropriate, but they ultimately didn't decide on that as a matter of law so much, right? So the matters of law here that were decided: 1, the court makes it clear that states can order a non-resident to turn over property within its boundaries, i.e. Quasi in rem. However, to assign a property away from a person living out of state, the property must be attached to the suit at its onset. And the reason that is important is because the court assumes that a property owner is in possession of the property, and so seizure of the property by the court is, or partial seizure, is something that makes the owner aware, at least according to courts, and that's something courts have to assume, otherwise you could never seize property unless the owner was there. So, right, that can also be dangerous, right? You don't want to seize the ranch of a guy who's, famous for shooting at people who come onto his ranch without his permission, if that can be avoided, where you don't want to do that while he's there. So you seize that while he's not there, and him coming back to the ranch, he'll notice that it's been seized. So that's a general assumption that the courts are going to make. But that seizure and that posting and all the information related to the seizure needs to start at the onset so the person can properly respond. Because in this case, the judgment was issued against him without the property being seized. Because the property was not attached, he was not alerted to the lawsuit via property seizure or property lien being placed on the property, or however process the court might go through there. But so the judgment was issued, and he couldn't fight the judgment because a default judgment is a default judgment. You can't fight it. If you don't show up to court, you lose. That's my number one new piece of lawyer advice as a 1L, not a qualified attorney. My number one piece of advice is show up to court or you're in trouble. A summons is a summons, and you have been summoned. Please answer the summons. If the king summons you, if the wizard summons you, and if the court summons you. All of those are three cases where you really should answer the summons. Now, because it wasn't attached at the beginning, he was never alerted that it might happen. And so because of that, the attachment or the non-attachment was invalid. And so the judgment against the property itself was invalid. The judgment itself against him may or may not end up being upheld. This lawsuit went through a lot of different opinions and decisions, and I don't have access to all of them, or I do, just take a long time to sort through all of them, and they're not relevant. This is the Supreme Court decision that is relevant in terms of law. So it also makes it clear that serving claim through publication against non-residents is so ineffectual as to automatically promote fraud. It does say that. Now, for several reasons, as a matter of law, that's unimportant because it will be contained within another decision that I'll explain in just a minute, but it's saying that you can't do that for just basic reasons of policy. It needs to be logical. Reasonability is a genuine judgment for policy. Policy that exists solely to maybe harass someone is not logical policy. Policy must pass a basic standard of reasonability and must have genuine public purpose. So a person from out of state must be physically served with process well in the state for the store to have personal jurisdiction over the served party. There are a few exceptions, notably divorce and civil status, so divorce being the main one. But if someone is not in the state, they can't be served. So they can't be forced to appear in a state court unless they're present in that state at that moment, or again, someone who domiciles in the state. And that's very important because it basically says you must have in personam jurisdiction in order to, or in personam power, i.e. they must be in person, in order to make most decisions against them as a person, but not against their property that is within the state. So if somebody's in the state and they have property out of the state, even if they're non-resident, you can take that property through civil procedure if they're served in the state. But if they're not served in the state, you can only take possession of the property that is within the state. I believe that should cover just about everything about Penoyer. I understand I spent a long time on it. It was a little rambling, but it is very important to the general understanding of state jurisdiction. I normally will save this for the end, but I'll say this now. If you have any questions about Penoyer v. Neff, it would be really good to leave those in the comments. One, because it helps me. The more I talk about a case, the better I'm going to do on it. But even more importantly than just having that in the comments, it could also help you clarify it. And this is an important case, and if you're actually following these for genuine, legal enjoyment or legal understanding, it would be valuable for you to have Penoyer v. Neff in sort of your head and understanding how civil jurisdiction generally works in the United States. Now on to Hess v. Poloski, not Pelosi, Poloski. So Hess was struck by Poloski while he was driving a car, which caused an injury. Poloski was not served, and none of his property was attached to the suit. Now, the law of Massachusetts on the book says that use of its road by non-resident inherently allocates a member of the state government as a potential receiving agent. Now, that is a complicated sentence, but basically there's a statute in Massachusetts that says if you are using its roads and you do not live there, I think technically if you do live there as well, there's another way to do this, similar procedure, but you can serve the person, i.e. give them the laws who tell them they're being sued, through a specified public agent, a specified employee of the government, who will then forward it to the other person. Now, what they're saying here is that this person is acting as a what was the phrase here? As a receiving agent. You're automatically, implicitly allocating a state employee as a specified state employee, some commissioner, as your receiving agent. And to be clear, if you have a receiving agent in the state, that is the same as you being served, right? If you have an attorney who lives in your state, he can be served, and he is a receiving agent. No, an attorney is not inherently a receiving agent. But if he is your receiving agent and you're not in the state or don't live in the state, but your attorney is, then they can serve you that way, and that counts. Assuming, again, they are a receiving agent. They must be a receiving agent, which is just someone who can take a lawsuit for you. It's a specified role that, generally not great to specify if you want to avoid being under the jurisdiction of a specified state court, but, a lot of people need them. If you have business in a lot of states, or if you're a corporation with business in a lot of states, you're going to need receiving agents in the states that you're operating in. Or in some cases, someone might be designated as a receiving agent for you, which we'll talk about in the next case. But so the person, if they are a non-resident, allows the state government to be the receiving agent for them. Assuming the suit arises out of something related to the roads, some use of the roads, motor vehicles, accidents or such. Now, this is allowed, the Supreme Court says, because the state can regulate the use of motor vehicles in their state. They're 100% permitted to do that. And if you're using a motor vehicle in their state, you are consenting to fall under their laws, right? And you maybe don't know all their laws, right? You don't have to know all the laws for the laws to apply to you. Ignorance is never a defense, except in front of a jury, to be very clear. You can definitely try to say, well, I didn't know the law, so it wasn't illegal in front of a jury. And they will not probably be very kind to you. But it's a defense that people have used, and some have succeeded with it. So the state can regulate the motor vehicles, and implied or implicit consent in almost every case is equal to express consent. Now, there are issues with that concept, but implied and implicit consent are important, right? Most people don't go around saying the phrase "I consent" or anything like that. So it's important that implicit or implied consent exists, and there are ways that can be abused and misused, but this is not a lecture on implied consent. This is just explaining what the law is related to civil jurisdiction. So since they have consented to that person as a receiving agent implicitly by using their roads, that inherently means that you have consented, right, to be bound by their jurisdiction, since you have a receiving agent in the state, meaning you are bound. Now, this is a pretty interesting case. It's sort of contrary to Penoyer. It's definitely limiting what Penoyer is saying. The previous case, it's saying, again, you will be subject to it if there's a law that says you will be subject to it, and you consent to that law through, whatever means, right? There might be a law that says if you drink the state water, you are liable for any water-related lawsuits to have the governor as your receiving agent. That would be a permissible law. What they're saying is if you use state resources and you have incidents related to that state resource, you have consented to the laws related to that resource by using it, and therefore it's okay for that law to stand. That was, again, a little rambly. I apologize. It's a little late, and these cases are fairly complicated, but hopefully that explains it. So, because, again, they can regulate these things, this regulation is totally allowed because you consent to it. If you don't want to automatically consent to the laws applied to a state resource, then you simply should not use that state resource. Or you should, know all of those in advance and then decide whether or not you're willing to consent. But we consent to state laws when we enter a state, and we consent to be bound by them when we use state resources. Now, two issues. In the next case, International Shoe versus Washington, there are two issues. Whether an activity of a corporation in a state means that they consent to the proceedings of a court in that state. So basically saying, if you're a corporation, corporations are fictions. They're not real. There is nothing about a corporation that makes it real. Corporations are made of people. Corporations as legal persons are a necessary legal fiction. For those of you who want to argue about campaign finance, comments are directly below. Engagement is free. But generally speaking, groups of people are people. A legalized entity composing of groups of people has the same rights and duties as a singular person, which as a legal fiction makes complete sense. Otherwise, how would corporations even function if they did not have rights and duties? They would be even worse. And if something has duties, you generally have to give it rights as well. That's contracts for you. So, so, so again, so acting in a state, does that mean you consent to the proceedings of the court in that state? And then whether a state can extract value from that corporation on a consistent basis while still complying with the due process clause, i.e., can a state make a corporation pay taxes if their activities in that state are, we'll say, somewhat limited, which in this case they were somewhat limited. The answer is yes. What taxes can they make them pay? Depends on the activities. In this particular case, it's unemployment taxes, payroll taxes related to unemployment. So the corporation at issue here did not have offices in Washington. Instead, it had salesmen who solicited orders. These persons were paid by commission, which they led to argue that they were not employees. Washington said, no, that's an employee. And the federal courts said, yeah, Washington gets to determine whether or not that's an employee. If Washington says it's an employee, then yes, because their definition, because we're using a state law here, the state definition of that law is what matters. You've consented to that law if you've got employees in the state, and the state says you have employees in the state, and the state gets to determine that. So you've kind of lost automatically. Trying to argue what the definition of a word is with the person who has the legal right to define that is not usually a good idea. Yeah, so that's basically what they were trying to do here. The court determined also that because the contracts were created within the state, the contracts for sale, the state was proving that there was presence of a corporation within the state. That's a fact, right? This is a question of fact here that the court is in many ways deciding. It's an appeals court, so maybe it shouldn't be, but saying, contracts created within the state proved the presence of a corporation. Now that's a matter of law and a matter of fact. So I guess it's fine for the appeals court to be deciding that, or I guess the Supreme Court in this particular case. This one's a really simple case, at least from my reading of it. It's, yes, the state gets to define what things are under state law, and the state gets to, and if you're acting within a state as a business, you are, you're subject to the laws of that state. And one other issue that was raised here was that an employee, one of the salesperson, was given the service, and also the service was mailed to the corporation. Now, the court didn't really make it clear whether one or both of those was necessary, or whether either would have been okay, at least from my reading of the case, but I generally what they said was, well, if you have someone in the state who is part of the corporation, that's inherently a receiving agent, right? Because corporations are legal fictions, a corporation can't actually receive a lawsuit. How would you give a corporation a lawsuit? You have to give a person who is part of that corporation a lawsuit. So automatically, people within a corporation are automatically receiving agents if they work for the corporation. Again, that's a little more of a nebulous issue that's not fully related to what we're talking about here. Receiving agents are an important concept to understand for civil jurisdiction, but especially for Hess, but less so generally for international shoe. But again, the court generally states that people within a corporation are receiving agents. Now, I imagine that precedent has been modified. I don't think I could walk into Subway and hand a Subway employee a lawsuit, but I wouldn't be shocked if I could walk into Subway and hand a Subway manager a lawsuit. I think that would be probably permissible. But again, I don't know the full precedent. One other thing to discuss really quick while I'm just here. Cases are not always still precedent, right? So if we go and talk about Roe v. Wade, which I imagine I will get to that at some level, that's not standing precedent anymore, but it's still necessary to discuss. So some cases that are no longer precedent are important to discuss just to understand the evolution of doctrine. So in this case, I imagine these are all still precedent, but it's just good to keep in mind that just because I'm discussing a case does not mean it is active law. The phrase there is positive law. Last case, another one that kind of confused me with its simplicity, so I probably missed something, but that's also why I was a little unsure about the previous cases. Sometimes I miss something. I'm not perfect. I know. Terrible news. But so the next case we're talking about is the Goodyear case. So Goodyear Dunlap Tires Operation SAV Brown. Goodyear versus Brown. Sometimes you have these really long case names. Lawyers shorten them. So the issue here is, are corporate subsidiaries of U.S. corporations, international corporate subsidiaries of U.S. corporations, liable to a state for activity outside of that state? A tire in France caused an accident which mainly affected North Carolina citizens. So is the manufacturer of that tire under the jurisdiction of North Carolina court? You must already see the problem here. No. I mean, obviously, right? No. But that subsidiary is owned by a U.S. corporation. So then, maybe, yeah, a U.S. corporation if it was their fault. Now, these tires had entered North Carolina through the general stream of commerce, but that does not establish, some of these tires, not the tire that caused the car accident, but that does not establish general jurisdiction over the corporation in question. Just because through the flow of commerce, an action figure made in Japan got to California, that does not mean that a California resident can sue the Japanese corporation for false advertising, assuming the advertisement wasn't happening in California. Right, let's say that they buy it and the box has something incorrect on it. Yeah, they can't sue that corporation because the corporation didn't do anything in California. Again, assuming they didn't ship it to them, say Amazon was the one who shipped it to them, or UPS, or they ordered through one of those reselling Japanese product sites. There's quite a few of those. That's incidental. That's not intentional. And they also tried to argue that the tires met U.S. safety standards and intentionally did so. That is somewhat relevant, they said, but essentially so many corporations that don't sell tires in the U.S. actually do that just because meeting U.S. safety standards is always a good thing to do. U.S. safety standards are somewhat higher than non-EU countries, so they said that yes, they're potential U.S. products, but they're not being sold in the U.S., at least not intentionally. Now, similar tires were produced by the USA corporation, the one that owned these two. But yeah, the USA, ultimately the United States company, the U.S. Goodyear, was kept on as a party, and the other two were dismissed as parties because it was intending to do business in the United States and in North Carolina specifically. The non-U.S. subsidiaries were not included as they were not actively doing business in the U.S. Now, a theory was brought up here, the idea that corporations and their subsidiaries are unitary. That was a non-starter. That's why there are so many subsidiaries. Subsidiaries can reduce liability. They can do a lot of different things. Now, quick to note, that would not help them escape. They could not, put a bunch of funds in a subsidiary that they own, right? Because say I take $1 million and I put it in a subsidiary, and we'll say that the subsidiary's sole purpose is to be the legal owner of an account worth $1 million. Well, then that subsidiary is worth $1 million. And so, say someone sues me, sues the corporation for $1 million, they could totally retrieve that asset by suing the corporation, which would then be forced to have a judgment pressed against it. Because the court would have in-person jurisdiction here, they could take property that was not particularly in the state. Again, because as was discussed in both Hess and Neff, or Penoyer, if you're in person, the state can get your stuff that's even not in the state, and corporations are considered to be personally in the state if they're doing business in the state, which the U.S. company, which owned the other two companies, was. All right, and so that's a quick overview. Quick term I meant to mention, general jurisdiction. General jurisdiction is what a state has over someone who lives in that state or who is in person in the state. It basically means, you have pretty much complete power over them and their assets. And they have to be in person in the state or be someone who lives in the state. If they don't have that, which would be like an in rem or a quasi in rem, they have special jurisdiction, which is just to say a limited power over them. And then obviously general is you have more complete power, not complete power. The final thing to note here is special pleadings, which is how a lot of these cases are happening. They're saying, I would like to file a motion without submitting myself to the jurisdiction of the state. If you're arguing whether or not a state has jurisdiction over you, you are not inherently saying, yeah, you have jurisdiction over me, because you're about to tell me whether or not you have jurisdiction over me. So that's called a special pleading when they do that. That's essential for the proper, operation of the courts. If you could only determine whether or not they have jurisdiction over you by submitting to their jurisdiction, by completely submitting to their jurisdiction, that would be a problem. All right. Well, hope you all are having a good one. If you have any questions, please leave them in comments. See you soon, probably tomorrow night.